Good morning, everybody. My presentation is about the relationship between corporate governance and financial regulation. Actually, Korea enacted special act to regulate the corporate governance aspect of all types of financial companies in 2006. Its name is Act on Corporate Governance of Financial Companies, enacted on July 2015 and took effect from August 2016, just last year. Globally, since 2008, global financial crisis, many scholars pointed out the corporate governance problems of financial companies as a cause of financial crisis. In particular, excessive risk-taking by short-term performance-based management behavior of executives and employees of financial companies. And also in Korea, we had many corporate governance scandals involving financial companies. For example, about the corporate succession of financial holding companies like Shinhan Financial Holding Company, and also power struggle within management in the case of KB Financial Holding Companies, and also many mutual savings bank went bankrupt because of the mismanagement of controlling shareholders. So the Korean government decided to make new special act to regulate corporate governance aspect of financial companies. Financial Services Commission, FSC, is Korean financial regulator and government agency. Actually, this commission is composed of 9 members, and I'm one of the commissioners in this commission. And FSC submitted to the National Assembly, Korean Parliament, a bill on corporate governance of financial companies, and the result is this special new act. The main features of the Corporate Governance of Financial Companies Act are as follows. At first, it is to reflect global reform agenda proposed after 2008 global financial crisis. And second, it is trying to deal with corporate governance problems specific in Korea. And third, it is also to accept aspects of financial companies' corporate governance as subject of financial regulations in addition to corporate law. And finally, it is trying to simplify corporate governance regulations for financial companies with single law. Almost all financial companies, including banks, financial investment services providers, securities companies, and futures companies, and insurance companies should be a stock company in legal form as an entry requirement. So financial companies are also subject to corporate governance rules of the general corporate law as a stock company. As a background, Korean corporate law, its name is Commercial Code, enacted in 1961, was originally based on German model, but nowadays more influenced by American corporate law, and our financial law was originally based on US model. But now, after 2007, our financial regulatory system is, generally speaking, based on UK model. Yep. Corporate governance of financial companies is different from that of general industrial companies. General industrial companies' corporate governance is to maintain checks and balances between shareholders and executives. But in the case of financial companies, corporate governance is to address the interest of other stakeholders, such as depositors and creditors, and the whole financial system as well. Actually, this issue was one of the an issue of hottest debate in Korea. In particular, insurance companies very actively opposed this idea because in Korea, some insurance companies are playing a role as holding company, de facto holding company for business conglomerates. So, under this new act, financial regulators can intervene a corporate governance system of financial companies. So they don't like the idea of intervention by financial regulator. So a Japanese professor, Professor Kato in Tokyo University, emphasized that the compliance of corporate governance rules of the corporate law lead to alignment of interest between managers and shareholders of financial companies, and it can trigger excessive risk-taking by managers for short-term profit. And also, we can note the potential conflicts of public interest of financial stability and the value of maximizing profits. And also, we can say or point out the absence of controlling shareholders due to the diversification of stock holdings and inability of traditional corporate governance rules caused by it. For example, in Korea, the Banking Act strictly limits the shareholding of the same person in Korea, in principle, 4% for industrial companies. So the role of traditional corporate governance structure is limited. But some scholars in Korea noted that corporate governance structure of financial companies should be governed by general corporate law in principle. And yep. So the Corporate Governance of Financial Companies Act provides that in relation with other acts, if there are no specific rules in other finance-related statutes, the Corporate Governance of Financial Companies Act shall apply. And the purpose of the Corporate Governance of Financial Companies Act is three: to protect the safety and soundness of individual financial companies, and to ensure the stability of a financial system, and to protect financial consumers. As a regulation, corporate governance regulation of financial company should be understood as a part of prudential regulation. Basel Committee on Banking Supervision explains bank governance as a core principle for effective banking supervision as well. And Also, the regulatory objective of the Corporate Governance of Financial Companies Act may decide the scope of the new act. So the Corporate Governance of Financial Companies Act, the primary purpose is to regulate large financial companies which has systemic influence in Korean financial market. So it excludes financial companies that are overseas subsidiaries and branches, or financial companies whose asset size is below certain levels, small financial companies. There are also strong arguments to apply same principles. I mean, the Corporate Governance of Financial Companies Act to general industrial companies. But in my view, we must consider the different risk profiles and systemic effects. There was also some discussions on the sector, I mean the banking, insurance, and securities business. Those sector characteristics of financial industry must be reflected in the regulation of corporate governance for financial companies. So, but the new act's understanding is the main point is degree of systemic effect by size and scale of business, not the difference of business type or sector. So the new act applies same principles to all types of financial companies, including banking, securities, and insurance companies. So the new act applies all sectors of financial industry. But there were some arguments to point out the limits of direct discipline by law in the area of corporate governance. So as for the matters to be defined by the enforcement ordinance or the supervision regulation in accordance with the new act, it should be continued to confirm the validity even after the enforcement of the new act. There was also some discussions on the application of principle-based regulation in the area of corporate governance of financial companies. And before the enactment of this new act, we had a code of best practice for corporate governance of financial companies, but this code of best practice is no longer applied. So the new act, Corporate Governance of Financial Companies Act, is based on understanding. Actually, this is a result of compromise in the National Assembly. So I used the term agreement. But this new act is based on understandings on the points, justifying a more strengthened role of financial regulation and supplementing the limits of conventional corporate governance rule in financial companies. For example, under this new act, the financial regulator, the FSC, can screen or examine the qualification of controlling shareholders of financial companies, and if the controlling shareholders cannot satisfy the requirement, the FSC can limit the exercise of voting rights of controlling shareholders. So very powerful and intervention is possible under this act. But considering the systemic implications of the business of financial services, financial regulation can intervene to regulate the corporate governance structure of financial companies. Actually, I was a member of the drafting committee for the new act. Yep. Thank you very much.